Now, for somebody that voted for Justice Ginsburg on our side, you had to know what you were getting. You were getting someone who was very talented, extremely well qualified, incredibly smart, who was general counsel for the ACLU. You had to know what you were getting, but you understand that President Clinton, in that case, had the right to make that decision. What happened to those days? I would argue to my Democratic colleagues, and I'm sure Republicans have made our fair share of mistakes when it comes to judges, but this effort, not too far in the past, of filibustering judges, declaring war on the judiciary, has really hurt this body. And in my opinion, the politicization of our judiciary has got to stop for the good of this country, for the good of the Senate, and for the good of the rule of law in America. Now, what am I trying to do today? I'm trying to start over. The political golden rule is do unto others as they did to you. The actual golden rule is do unto others as you would have them do unto you. I hope we can get back to a more traditional sense of what the Senate has been all about. And that brings me back to the recent past. This body was on the verge of blowing up. Our Democratic colleagues were filibustering President Bush's nominees for the appellate court and even the Supreme Court in a fashion never known by the body. There was an effort by frustrated Republicans to change the rules so that all you needed was a majority vote to get on the bench, the Supreme Court. And this body for a couple of hundred years had not gone down that road. A gang of 14 was created, 7 Republicans and 7 Democrats that tried to find a better way, tried to get the Senate back to a more reasoned position. And what we did, 7 Democrats and 7 Republicans, we said that filibustering judges should only be done in an extraordinary circumstance. And we left that up to the members of the body, but we were focusing on someone who was clearly out of the mainstream when it came to judging. And if you look at Judge Sotomayor's record for 17 years, it has left a center, but not a record of someone who is wearing the robe, but under the robe is an activist. An extraordinary circumstance would be somebody clearly not qualified, a pick political in nature alone. Well, I am glad to say that my colleagues on the Democratic side and the Republican side who were part of that group and are still here did not see an extraordinary circumstance. And I would like to compliment Senator Sessions, who did a very fine job in this hearing. He has acknowledged there is nothing extraordinary about this nominee for the Republican Party to try to block her through filibustering. I think that is a correct assessment. But then it comes down to your individual vote. I've tried to indicate the best I can that I desire as a senator to find a new way to start over and get back to a Senate that's more rational in its approach when it comes to confirmation. Having said that, to my colleagues who vote no, I understand your concerns, and there are things about this nominee that are troubling. The speeches that she has given in the past are troubling because I think they embrace identity politics, something I don't embrace. The wise Latino comment that's become now famous, that she believes more often than not that a wise Latino woman with her background and experience would reach a better conclusion than a white male. We had a long discussion about how that does not set well with most Americans, and that is not what we want to be expressed by people trying to become Supreme Court nominees. But having said that, do we want to exclude from consideration people with boldness, that are edgy? Do we want milquetoast nominees who are afraid to speak their mind and to disagree with their fellow citizens? I think not. Her speeches, while troubling, have to be looked at in terms of her record. And when you look at this 17-year record, you will find someone who has not carried out that speech. And I will take her at her word. She rejected this idea of picking winners and losers and was very mainstream in her understanding of the role of a judge, understood the difference between a policymaker and a judge. I will take her at her word. I cannot understand her heart any more than she can understand mine. The speeches are troubling, but I guarantee you I've made some speeches that are probably troubling to people on the other side. I hope they would look at everything I've done, not just the speeches I may have given. Her time as a lawyer. This is very important to me. During the Alito and Roberts hearings, they were really pushed hard about some legal memos they wrote for Ronald Reagan espousing conservative thought and how that made them dangerous. How dare you write a memo about the Civil Rights Act that somebody on the other side may disagree with? Well, lawyers who advocate positions should not feel chilled in terms of picking their clients if they hope to be a judge. The worst thing we could do is take a lawyer's advocacy position, their clientele, and hold it against them from being a judge. She was a board member of the Puerto Rican Legal Defense Fund. Some people say we shouldn't talk about her time as a lawyer, even to mention that organization. I do not believe that at all. Because when I'm looking at this nominee, I'm looking at every aspect of their life. And during her time as a board member, the board and the organization advocated positions, I think, that are out of the mainstream that I don't agree with, but certainly are legitimate positions to take, like taxpayer-funded abortion. I could not disagree with her more. I don't think most Americans want their taxpayer dollars to be used to fund abortion. The Puerto Rican Legal Defense Fund argued to the court that if you do not allow taxpayer-funded abortion for poor women, it is a form of Dred Scott kind of oppression. Well, I couldn't disagree more. But that's not the point. Disagreeing with me is okay. Now, what I hope will happen in the future is if a conservative gets in the White House and we pick someone that was on the other side of that case, you will have the same understanding I do. Being aggressive advocate for causes I disagree with doesn't disqualify you from being a judge if otherwise you've demonstrated the capability. The advocacy role of a lawyer is unique. I have represented people who I disagree with. I've represented people accused of child molesting. I've been a criminal defense lawyer. There's nothing more noble in our system than making the government prove their case regardless of how you feel about the defendant. So the fact that she was an advocate choosing causes I disagree with does not, in my opinion, disqualify her.